Welcome to Core Bar Studies, the Criminal Law Sessions. This is Professor Jack Guttenberg. This session will focus on accomplice liability and solicitation. We will begin with accomplice liability. Accomplice liability contains numerous elements, the first being with the intent to aid, encourage, or counsel. And any amount of aid, encouragement, or counseling will do, even to the point of merely clapping and encouraging the defendant to commit the crime by cheering them on will be sufficient. Another, to commit a crime with the intent that the person commit that crime. Let's distinguish now between principals and accomplices. Principals are the ones who actually commit the crime. They are the person who walks into the bank and says, "This is a holdup, give me your money." Accomplices aid, encourage, or counsel with the requisite intent. They can be providing the bank robber with a gun, waiting outside in the getaway car, hiring them to do the crime, doing anything that encourages, counsels, or aids the principal to commit the crime. So here we have an accomplice and a potential defendant. The accomplice has the intent to aid and the intent to commit the crime, and he says, "Here's a gun to use to kill my professor." The principal takes the gun, shoots, and indicates that they just shot the professor dead. So we have an accomplice now, and we have a principal. And both are guilty of murder. Under accomplice liability, the accomplice has the same guilt as a would-be principal. There are some special issues that come about in accomplice liability. Accomplice liability is derivative. That is, the accomplice's liability for the crime flows from the principal. However, that does not mean the principal need be convicted. In fact, under modern criminal law, the principal need not be convicted. All that must be shown is that there was a principal who committed a crime and the accomplice aided. The principal does not need to be caught. The principal does not need to be charged. The principal does not need to be convicted. The principal does not have to be anywhere around, and in fact, the principal may be found not guilty and the accomplice still convicted. Accomplices are responsible for crimes that they counseled. That is, if in the previous example, the accomplice counseled and aided in the commission of the murder, they are responsible for that crime. They are also responsible for any crimes committed by the principal in the course of committing the contemplated crime, as long as those crimes were probable and foreseeable. So accomplices are responsible for any crimes committed by the principal that were probable and foreseeable. So back to our example. They have the requisite intent to aid, the requisite intent to commit the crime. Here's a gun to use to kill my professor. The principal takes the gun, shoots the professor, but also indicates, "I killed the security guard when I had to break into the building." Both are guilty of 2 murders and a burglary. We have our principal who actually did the 2 murders, shot the professor, and killed the security guard, plus broke into the building, which could be a burglary, and we have our accomplice who is guilty of the murder that they counseled, that is the professor, plus the murder of the security guard and breaking into the building, because most likely those were probable and foreseeable events flowing from the principal killing of the professor. One can withdraw from accomplice liability. and this must occur before the actual principal commits the crime. They must communicate their withdrawal to the principal, and they must make bona fide efforts to neutralize the effect of their prior assistance. Example, they remove their encouragement, they take the gun back, they notify the authorities. These are all examples of what one may do when they are withdrawing as an accomplice. Now, back to our hapless accomplice and principal here. We see they have the requisite intent. We see the accomplice says, here's a gun to use to kill the professor. The principal takes the gun, but one day later, the accomplice shows up. I've changed my mind. It is wrong to kill the professor. He just gave me an A. Give me my gun back. Okay. And the defendant gives the principal the gun back. But 2 days later, the principal gets a different gun and kills the professor. So now the principal is guilty of that murder, but the accomplice now has the defense of withdrawal and would not be guilty as an accomplice to that murder because they took back the aid that they had provided. Let's go on and talk about the next topic here, solicitation. This will be a very brief discussion of solicitation. Solicitation occurs when one is inciting, counseling, advising, inducing, urging, or commanding another to commit a felony with the intent that the person solicited commit that crime. So we'll go on and see an example. We will see some other issues with solicitation in the next video presentation. So we have our two defendants here, and the one says, thinks I intend to hire you, I intend that you commit the crime. I want to hire you to kill my professor. At this point, the crime of solicitation is completed. That is all that is needed. The intent to solicit and the intent that the defendant commit the crime. That is all that is needed here. This concludes this video session.